Welcome everyone to our second QFKC webinar that is coming to you live. I want to start by acknowledging the traditional owners of the land in which we all meet today and pay my respect to elders past, present and emerging. I also want to put a big shout out to our Aboriginal and Torres Strait Islander foster and kinship care services that are out there that I know that have registered all the way up to central Queensland, where I was up recently doing some training up there. So hi to you all, and Cowan, who I often go out and do training with. So thank you for joining us today. My name is Carissa Inglis. I'm the Service Support Manager for Queensland Foster and Kinship Care, and I've worked for the organisation for 16 years. And so through that time, obviously, the QCAT has been a huge part of the work that QFKC has undertaken, and it's really important that carers have an understanding of what QCAT can and cannot be used for. And so we really hope that after today's session, you carers and foster and kinship care services that are linking in today much better informed about what are review rights and what aren't, and what to expect in that QCAT process. I just want to remind everyone that today's session is being recorded. It will be placed up on our website and it will be able to be accessed. But I do ask that in the chat forum, there will be an opportunity for people to ask questions at the end. And I just want to remind people of confidentiality provisions within the Act, so that we don't provide any identifying information in that chat function, that questions are general only, and that if you do have a matter that requires actual specific information, then please contact our QFKC office on 32566166 and ask to speak to one of the on-call workers, and we will be able to help you out with those individual matters. Okay, so I think that covers all of the housekeeping. So like I said, today is around understanding QCAT for foster and kinship carers. We'll actually do a separate training on children's court and helping carers and the sector to understand carers' role within the children's court, what you can, cannot do, how those decisions are made behind the scenes. But today is around QCAT, which is a process that carers can be very much involved in. And so we're going to get started, and these are the things that we're going to talk about today. So we're going to talk about what is QCAT, and we're going to have a look into the structure of QCAT. What are those reviewable decisions that carers are able to seek? And we're also actually going to look at what are the reviewable decisions for parents and what are the reviewable decisions for children and young people as well, so that you have a really good understanding about the review rights for everyone and what that QCAT process is. So I started with this organisation in 2006, and way back then it was called the Children's Services Tribunal, and there was a whole lot of small tribunals that existed. Things were a lot simpler back then, but in 2009 there was a situation where all of those small tribunals came together. The only one that was actually not included in this big QCAT super tribunal, so to speak, was the Mental Health Tribunal. So other than that one, all of the other ones were pulled together for this QCAT. So it was 23 old tribunals into one. And of course, that included the Children's Services Tribunal, and that started in December 2009. There has been a review done into QCAT, and that was done in 2013. And for anyone that's interested in that, you can go online. Obviously, I think we're very much due for another one. There has been some, particularly with COVID, some challenges really in relation to timeframes and getting matters heard in a timely manner. And what we know is that for matters to be fair and just, then they need to be heard in a timely manner, and that's one of the worries that we have at the moment. So what does QCAT look like? We have three divisions in QCAT. One is the human rights, one is disciplinary, and one is civil and administrative disputes. So if we look at where children's matters and carers matters are heard, it's under the human rights division. So under that division, we have guardianship and administration matters. We have children's matters, and that includes blue card matters. And then we also have just anti-discrimination matters. So we've got 3 divisions, but the one that we work under is the children's matters, including blue cards matters. So the structure of QCAT, so when I talk about how it looked in the old days, under Children's Services Tribunal, it was much smaller and it was much more intimate, so to speak. QFKC, or we were FCQ in those days, would actually have stakeholder meetings every 3 months with the Children's Services Tribunal. And the president of the Children's Services Tribunal back then was actually a social worker, Julie Ford, who continues to be a senior member in QCAT these days. It was just a very, very different structure. And that was why, if anyone experienced a matter in the Children's Services Tribunal, it was much more informal and it was much easier for carers, QFKC and anyone else to navigate those processes. When it changed to QCAT, originally it was still pretty easy. There was still stakeholder meetings that would take place in that children's division for a period of time, but that has certainly not been the case for a number of years now. And unfortunately, the more years that have gone on, the more formal it has become. And that has been influenced, I think, also by who the Supreme Court judge is, that is the president of QCAT, because obviously they drive some of that practice as well. So the president of QCAT now is a Supreme Court judge, and the deputy president is a district court judge. So you can understand how the process has become more legalistic when it's been driven at that level. So directly under the deputy president, QCAT has senior members who all have full-time positions within QCAT. So then under the senior members, we have full-time members, adjudicators who are all lawyers, and then we have over 100 sessional members. And in those sessional members is membership of Aboriginal and Torres Strait Islander people as well. And we're going to talk about the importance of children's matters, because when we look and remember what QCAT is, it's all those 23 tribunals into one. So those sessional members are looking at dispute matters in respect to small claims and rental, and a whole range of matters are being considered. And one of the worries that QFKC had when we went from Children's Services Tribunal to QCAT was recognising that the decisions that are made and put forward to panel members in QCAT are life-altering decisions for our children and young people and for the carers that provide care, and of course with birth parents as well when they're having reviewable decisions. So we were really worried that that the panel members may not have the necessary skill to be able to understand child protection and the complexities of that and make decisions that were consistent with that knowledge. So that we had the opportunity prior to QCAT becoming live to actually put submissions forward about what it was we would like to see in this new QCAT kind of structure. And certainly I know that the Child Safety and QFKC and other agencies also talked about the importance of having it in legislation that a panel member sitting on a children's matter had to have child protection experience of some description. So that now the QCAT recognises that children's matters are specialised, and therefore the need to have panels that reflect current child protection knowledge is reflected in the Enabling Act that underpin QCAT. So that's in the Child Protection Act and the Working with Children Act, which of course is the act that governs the blue cards. So who would you expect to see in a panel? You would expect to see 2 panel members for a compulsory conference at least. 3 panel members will make up a children's matter for a stay and for final hearings. So if you're only having a compulsory conference, and we're going to talk all about what a compulsory conference is and what a stay is, but just talking about membership at the moment. So in terms of membership for a compulsory conference, you only have to have 2 panel members. But for a stay hearing, and we're going to talk about what a stay hearing is as we go on, and for a final hearing, you have to have 3 members. Now, one of those members must be a lawyer, and one of those members must have knowledge in respect to child protection. And there is a provision within the Act as well that if the matter relates to an Aboriginal or Torres Strait Islander child or carer, there is a requirement that an Aboriginal or Torres Strait Islander member sits on the panel if practicable. Now, it says if practicable because there are limited members that identify as Aboriginal and Torres Strait Islander, and if they have no availability, then obviously that means that the matter would continue to be adjourned, which may not be in the child's best interests. So there needs to be some consideration for that. Okay, we're going to go through now what decisions can be reviewed. The next couple of slides are going to be pretty confusing to some, potentially, because it's very wordy. But what we do in the slides following that is we put that into context about what that actually means for carers. So what is the situation and what a carer can do. But for now, we're just going to go through what the Child Protection Act defines as reviewable decisions. So, and this is really important. The reason it's really important is because we hear about matters where carers have gone to QCAT to have a harm report reviewed, or have put an application to QCAT because the department won't consider guardianship, or a whole range of other things, and they are just not reviewable decisions. So what that means is QCAT does not have any jurisdiction to review those particular decisions. So nothing can be done. So you're putting in an application and you're using up all this time and energy, and in fact, that is not the avenue for those to be reviewed. The avenue for those things to be reviewed would be through the Department's Central Complaints process, and QFKC are currently putting together a training package that we will bring in this type of forum to you in respect to those. So today is just about what the Act says QCAT is able to review. So could you go back, Danny? Okay, so refusing a request to review a case plan. So what that means is that when a child is on a long-term guardianship order or on a permanent care order, and that child or that carer requests for the case plan to be reviewed, and if child safety say no to that, then that's a reviewable decision through QCAT. Now, I haven't come across any where the department have refused to review a case plan. So if you are a carer out there thinking about taking long-term guardianship, you only have a plan done once a year. If 6 months into that year, circumstances really changed and you really needed to have some additional support from the department, or required, a case plan review for whatever reason, then you would put that request to the department. If they said no, then you could actually make an application to QCAT to have that decision reviewed. For a permanent care order, you are issued with a letter at the beginning of the order. Not a letter, you're issued with a plan at the beginning of the order, but there is no requirement for a permanent care order for there to be reviews of case plans. But again, if, 5 years, 10 years down the track, things change, and you as a guardian or a permanent guardian feel that you need departmental support, you can put a request in to have the case plan reviewed. And once again, as a permanent guardian, if the department say no to that, they must issue you with a letter, and that's reviewable as well. Refusing to deal with a complaint about a permanent guardian. So for those that are familiar with the permanent guardian orders, when a PCO is granted, the only person or body that is able to make an application to revoke that order is actually the Director of Child Protection Litigation, which is the department's lawyers. Unlike a long-term guardianship order where a parent can make an application to revoke that order. So there are provisions therefore within the Act that if a parent is concerned about a permanent guardian not meeting their obligations under the Act in terms of what they must do, for instance, supporting contact, keeping the birth parent up to date, they can, or if they are concerned about the child's welfare, they're able to make a complaint to child safety, and the department have a process by which they have to respond to that complaint. If the department make a decision to refuse to review the complaint, then the person can take that to QCAT and have the decision not to review the complaint reviewed. So all that would mean in that instance is that QCAT could say to the department, you must review this complaint. So they don't actually look into the complaint, they just give direction about whether the complaint needs to be reviewed or not. So an example in that one would be if you had a parent that was continuously making complaints and that they were unfounded, and then after the third or fourth complaint, the department said, well, actually, no, we're refusing to deal with this complaint. The parent could actually lodge an application in QCAT to have that department's decision reviewed, and then QCAT can take an individual independent look into that to see whether there are grounds for that complaint to be reviewed or not. So deciding in whose care to place the child's parents or child subject to the decision, and not informing a child's parent of the person who the child is in. So the parent or the child. So changes will separate these two decisions. So there was legislation that was passed through on the 10th of May through the Child Protection Bill, but that hasn't been proclaimed yet. But parents have a right, so not informing a child's parent of where the child is living and in whose care the child is in. So those are the ones that currently are joint. And what is going to happen once the Act is proclaimed is that it'll be separate. So at the moment, the Act reads as though the department has to tell a parent where the child is and who the child is with. And so both of that information, it's not or, it's both. And so if the department refused to give the parent information about who the child is with and where the child is, then they have to provide a review letter. In the changes that will come into effect, the department will separate that. So there will be the ability for the department to say to a parent, well, this is who your child is with, but we're not providing you with details of where the child is, or this is where the child is, but we're not telling you who the child's with. So it's just separating that so it doesn't become and, it becomes or. Refusing to allow restricting or imposing conditions on contact between a child and a member of the child's family. And we're going to go into that in a little bit of detail as we go on. But basically what that means is parents and family members all have a right through the Act to have ongoing contact with their children, and those rights are protected in the Charter of Rights and the Statement of Standards and the Principles of the Child Protection Act. And because they are very much highlighted and it's so important that children continue to have a relationship with their family of origin, if the department makes a decision not to allow that, then it's important that the parents have a reviewable right, so that once again we have an independent body that is able to take a fresh look at that decision and ensure that that decision is in the child's best interests. Removing a child from the care of the child's carer, so we're going to go into detail about that. Refusing an application for or to renew a certificate of approval as an approved foster or an approved kinship carer. So you've been approved and you're up for renewal of approval, and the department have actually made a decision not to renew you. That's an appealable decision. Refusing an application to amend an authority. So let's say you had conditions on your certificate as a carer, and let's say one of those conditions, for example, was that you could only do respite care, that you were approved for a 2-year period only to do respite, and you agree to that. At the end of that 2-year, you're up for renewal. The department maintain that condition on your certificate. You say, actually, I'm putting a request in to amend my authority because I feel that I can do primary care now. If the department refused to amend your authority, then that's an appealable decision as well. And that does not relate to provisional approvals. So you don't have any appealable rights where there has been a restriction placed on an approval as a provisional carer. Suspending or cancelling an authority to care. So that is when so let's say you lost your blue card, or and therefore to be a carer you need a blue card. So the department would cancel your authority to care. And then again, that's an appealable decision, but again, not for provisional carers. Situations of suspending, we don't see those a lot, but that could be where the department has removed a child, or they're undertaking an investigation, and during that investigation they could take the action of actually suspending your care authority as well, which would mean that there'd be 2 appealable decisions. So what we're going to do now, we'll click on to the next slide and we're going to try and make this all make sense. So at a glance for carers, we're going to look at what the situation is and what the appeal right is. So let's say a child was removed from your care due to standard of care concerns. Okay, so there's been a harm report or there's been a standard of care review completed, and the reason why the child has been removed from your care is because the department have concerns about the care that you're providing. Now that's a QCAT removal decision, and what that means is that you can appeal that decision in your own right. So there's certain decisions when a child is moved from a carer's placement, which we're going to talk about, where it's not an appeal decision in your own right, but where you can make an application on behalf of a child. But all removal decisions are actually decisions that carers can make in their own right. So you don't need permission from the president of QCAT to lodge that application or to have that application heard. It's simply that you have an automatic right to have that application heard. So the situation, a child is removed from your care to be placed in another placement and is subject to a long-term guardianship to the chief executive. So in that scenario, it may be that they have no concerns about you as a carer. There's no child protection concerns, there's no harm report, there's no standard of care issues, but in fact, they have made a decision to remove the child because they have identified a placement that better meets the requirements of the Act. So it may be that they have located family and they're wanting that child to be placed with family. If the child is on a long-term guardianship order to the CE, that is a removal. So what that means is that you have an automatic right there to seek review of that decision through QCAT. Now, in that same scenario, if that child was only subject to a short-term custody order, you would not have an automatic right there because there's no child protection concerns. The placement, it's a placement decision. And although the child is being removed from your care, they're not on a long-term guardianship order. So you would still be able to make an application to QCAT, but you would be doing that on behalf of the child. And so when you make an application on behalf of a child, because the child has the review right there, then it's the president of QCAT that actually makes the decision as to whether it's in the best interest of that child for that application to be heard. And we're going to talk about that as we go on in terms of what is the process that the president takes to actually reach a decision in respect to that. So, like I said, a child is removed from your care to be placed in another placement and is subject to a short-term custody order. So that's what we just spoke about. That becomes the in whose care, and you're making an application on behalf of the child. So any new placement decision for a child, so whenever they are placed in a new placement, the parents and the child always have appeal or review rights. So a parent always has a review right if they don't agree with that placement, and a child always has that review right if they don't want to be in that placement. Now, obviously, it's very rare that children will make an application to QCAT in their own, in their own right, because they don't have capacity to do that. So that's where carers have that ability to make the application on their behalf. So another situation, let's say a contact decision is made for a child. So let's say the department go from unsupervised contact to supervised contact. Supervised contact to unsupervised. So the child's seeing mum and dad in a supervised setting, and then the department make a decision for that to go to an unsupervised setting. And as carers, you are very concerned for the child's welfare. Again, that is a decision that you would have on behalf of the child. So you don't, as a carer, have an automatic right. And if that was granted, it would, so when you request a stay for that, it goes back to what the contact decision was previous to the department changing it. So in that instance, it would go back to, if the stay was granted, it would go back to the contact occurring in a supervised manner. But like I said, that can only be done in instances where that the application is made on behalf of the child, and so it has to be child-centred and focused around why that decision is not in the child's best interest, and we'll go on to that in terms of submissions. Okay, now we're going to go into all the stuff about carer certificates. So if your certificate of approval is suspended, then you have a review right. You have that review right automatically, so you would appeal that decision. If your certificate of approval was cancelled, again, you have that review right. Now, the difference between when a carer's certificate of approval is cancelled as opposed to when it's not renewed are two very different processes that we need to be really familiar with. So in the event that a carer is up for renewal and they have their renewal of approval assessment completed on them, they get that document. So they're able to read the renewal of approval document, and the procedures are really clear in the practice manual that the carer should receive that renewal of approval document before it even goes to the service centre manager for final consideration, because the carer should have the opportunity to actually provide an addendum if there is anything in that renewal of approval document that they don't agree with. So that by the time it gets to the service centre manager, that the manager has the assessment and any addendum from the carer. So that's a very open process. It's a very transparent process. And the manager has all the information. The carer knows what information the manager has, and the manager can then make a decision not to renew. So they can then issue the carer with a notice that they're not renewing, and that's an appeal right. Now, the cancellation process is different. What needs to occur, and often what I guess triggers cancellations is that we often see a suitability assessment. Now, there's no requirement in policy or procedure that says that a carer is able to read that suitability assessment in its entirety. The statement of commitment certainly talks about carers having access to copies of documents that are about them, so we should be sharing that document. It should be an open and transparent process. But if the carer hasn't seen that suitability assessment, then they're not aware of what has been provided to a manager to consider in deciding whether they should propose to cancel a carer or not. So a manager can't just go from a carer as a carer to the cancellation. What the procedures say that they must do is that they have to do what's called a proposal to cancel. So in that proposal to cancel, the manager provides a letter to the carer, and in that letter should outline the fact that they are considering cancellation of their carer certificate and the reasons why. And those reasons should be as detailed as they possibly can be, so that the carer is then able to provide a response to that. So the carer has 28 days. At this stage, we're not in QCAT because no decision has been made. We're just doing a proposal to cancel. So the carer receives the proposal to cancel, and hopefully with the help of their foster and kinship care service or with QFKC, they provide a response to the proposal to cancel, and then that is provided to the service centre manager, and then they have their final consideration. Now, there's no time frame around that. A manager can take as long as they want, and that's the same with renewal. As long as an application is made on time, then a renewal document can sit there for as long as the manager needs it to make a decision. So once the manager, so they may make a decision that, okay, well, I've got additional information now and I feel like I can work with this carer and put supports in place and I don't need to cancel, so then therefore there is no further action. Or if they make the decision that actually this hasn't satisfied me, I still do not believe that this carer is meeting the legislative requirements to be a carer, and my decision is to cancel. They must then issue the carer with a letter, with the final letter to say we are cancelling. So we've gone from a proposal to cancel to a cancellation, and then that becomes a reviewable decision as well. So then carer has a condition on their certificate which Child Safety refused to amend. So again, that was the example that I gave you earlier, where a carer certificate may have that they can only care for children of this age, or it may have that they can only do respite. And in any of those situations, if the carer requests for that authority to be amended and the department don't, then that's a reviewable decision. And then initially, when the department places conditions on certificate of approval through amending the carer's certificate of approval and the carer doesn't agree. So that's not at that initial stage. So if a carer goes through their initial assessment, so they haven't been a carer and then they were approved for the very, very first time, and the department issue a certificate and it has a condition on it, the carer has to request for that condition to be amended in order for the carer to then go to QCAT if the department refused to do that. And then the only other time that the department, if we get to a renewal of approval stage, for example, and the department say, well, I'm going to approve, but I'm going to place a condition on the certificate, then that's an appealable decision as well, a reviewable decision. Okay, and then on top of all of those, so those are all sitting under the Child Protection Act. Those are all your reviewable decisions under the Child Protection Act. We also have reviewable decisions under the Working with Children's Act. So this is all in relation to blue cards. So that's issuing of a negative notice, the suspension of working with a children's blue card, and the cancellation of working with children's blue cards. So, you know, the cancellation, there could be a change to your criminal history or your child protection history. So blue cards consider disciplinary action when they are considering issuing a blue card at time of initial issuing, but also right throughout someone holding a blue card if there's any change to a carer's disciplinary information, which is outcomes of harm reports that result in things like suspensions, cancellations, that kind of stuff that can absolutely result in a blue card not being being suspended or cancelled. Usually what blue cards do, and I guess this is a big message to all the carers out there and to the agency workers, is that usually, unless it's, you know, a serious offence, a criminal offence, and blue cards cancel it straight away, if it's around disciplinary action, usually they'll do a please explain to the carer first to say, we have this new information, and, you know, it could be that there's been a harm report and that these have been the actions from that harm report, and we want you to explain. Then what I would say to you is to please contact QFKC if you can at that time for us to support you to do those submissions, because once the decision is made, the QCAT process can be quite drawn out. It can be 12 months before your application around that blue card cancellation is actually heard. And what we're finding more and more so, particularly since the review into blue cards, so once we had the TLE Palmer QFCC review in 2016, and we had a whole lot of recommendations made in relation to the blue card system and the foster care system. QFKC has seen a significant increase in the amount of carers losing their blue cards and not being issued with blue cards for reasons that were never the case prior to that. So we've had situations definitely where a carer has been through a harm report process with the department, where the department have substantiated harm, but where they have felt that they can work with the carer family with an action plan to address those issues. And then, you know, further down the track, when the carer is due for their renewal of their blue card, then they get a please explain around that. And the important information to recognise here is that the department and blue cards are looking at two very different things. When the department are looking at harm reports and criminal history and, you know, child protection history, they are determining whether this person is suitable to look after foster children, or, you know, for our kinship carers, it's often their grandchildren or nieces and nephews or what have you. Blue cards are not looking as to whether they're not issuing a blue card to a foster or kinship carer to be a carer. They are issuing blue cards so that that person can work with all children. There's not a condition on blue cards. There's never conditions on blue cards. When a blue card is issued, then what that is saying from blue cards is that this person is suitable to work with all children. So really different sets of eyes on both of those scenarios, and unfortunately we've seen some pretty sad cases where you know, children have had to be removed, in particular from kinship carers, because blue cards have felt that they're not suitable to have a blue card, and without a blue card, the department are not able to risk manage. A carer requires legally a blue card in order to be a carer. So we're seeing lots more of those. Okay, so I talked a fair bit before about the concept of making an application on behalf of a child. So that, you know, carers had their own review rights, which were automatic, and then there were certain decisions that could only be reviewed by a child or a parent, but where a carer could make an application on their behalf. So that's set out in the Child Protection Act under section 99P, and that allows for a person, so it doesn't have to be a carer, it can be the OPG, it can be someone else, to file a review application on behalf of a child with the President's permission. So the President may give permission only if the President considers, well, A, the person is not on the person's own behalf entitled to apply for the decision to be reviewed by the tribunal. So the President will first look at, is this a decision that the carer could be making in their own right? And if so, then they'll be directed to do that. And B, it is in the child's best interest that the application be made. So what that President will be doing is he'll be bringing his mind to the principles of the Child Protection Act, and obviously the paramount principle, which looks at the safety and wellbeing of children, not only now, but for the rest of the child's life. So that will form part of the decision, and that it would be inappropriate for or unreasonable to require the child to make the application himself or herself, for example, due to their age. So once the application on behalf of the child is filed, the applicant is then only able to withdraw the application with permission from the President or the tribunal. So all reviewable decisions whereby the child has a review right, a carer is able to lodge an application on behalf. So we talked about placement, we talked about contact. This would usually be the case for removal decisions where a carer is not the aggrieved person, for example, the in whose care decision and those contact decisions that we talked about before. So what will happen is that the carer will put the application in, and then the President will actually seek submissions from Tribunal, from Child Safety, and court services have a big role to play here. So court services are the department's section that looks after QCAT. The court services are not involved in children court matters. That sits over here, and that sits with the Office of the Official Child and Family Solicitor and the Director of Child Protection Litigations. So they all deal with the children's court matters, and court services deal with the QCAT matters. Now, it's important to note that the court services workers are not all lawyers. That a lot of them have worked for the department for a very, very long time and are very experienced when it comes to the Act and QCAT matters, but they're not themselves lawyers. But what court services do is that they support the service centres to put together the submissions around things such as when the President says, we want to hear a submission from you as a service centre or as a manager who's made that decision as to whether you believe that this application should be able to be heard on behalf of the child. Okay, so we're going to talk a little bit about process. So you should know when you have a review right, because Child Safety or DJAG, so when I talk about DJAG, that's the Department of Justice and Attorney General, and that's what Blue Cards sits under. They must provide you with a letter outlining the decision if it relates to you, so those automatic appeal rights, and provide you with details of how you can appeal the decision. Now, obviously, they don't have to provide a letter if it's a decision for the child, but that doesn't stop you from being able to request a letter to say, look, you've made this decision, it's reviewable for the child, and I'd like to have that decision reviewed. If the department won't issue a letter, then you can still make your application, and often court services will follow up and get that letter. So I guess even if you do have an automatic appeal right and you're not being issued with that letter, don't think that you can't make that application. The form will ask for that to be attached, but it can be lodged without it being attached if you've requested it and you just simply don't have it. So applicant must fill out an application form outlining what decision they're seeking to have reviewed and why they feel that decision is made is not the right decision. So the Form 17 is the one that is done for all children's matters. The application is then lodged with QCAT. If outside of Brisbane, applicants are able to lodge the application via their local magistrates court, but most applications now are just emailed. They can be filed in person, but they do accept them via email. So QCAT can be an extremely daunting process, and like I said, it's becoming more and more legalistic. There is actually legislation that states that the principal registrar must give parties and potential parties reasonable help to ensure their understanding of the tribunal's practices and procedures, including, for example, reasonable help to complete forms required under the Act or the rules. I think in reality, I think we need to be really mindful that QCAT, like I said, is made up of 23 tribunals. It is huge. It is very hard to even sometimes get through to QCAT. So whilst, you know, absolutely there'll be some assistance from the case manager or the principal registrar, it can be difficult to get that help. So that's where we come in. So I briefly spoke earlier about the old days in the Children's Services Tribunal, and QFKC used to have a role to act as agent for carers at times where we felt that the decision had not been made in the best interest of children. And I myself have acted as agent for a number of matters over the years. When it became QCAT, it became much more legalistic, and I'm not a lawyer, I'm a social worker. We don't have any legally qualified people here at QFKC. We all, our backgrounds are all in human services. So we found it more and more challenging, I guess, to help carers to navigate the QCAT process, because we, you know, when it came to those legalistic arguments, we were in and over our heads. So for a number of years, QFKC really rallied and advocated that carers, if we're going to have a process where carers can have decisions reviewed, then in order for that to be fair and just, carers have the right to be legally represented or have legal advice through those processes. They're not disadvantaged when we think that the department have court services available to them, and whilst they may be not legally qualified, that's all that they do, so that they sit in that space of QCAT and they're very, very knowledgeable. So we advocated and advocated and advocated, and finally in 2018, under Minister Farmer, we were actually given funding to employ a lawyer. Now, we couldn't employ the lawyer directly under QFKC because a lawyer requires a principal lawyer to provide supervision. So there was a process whereby we worked with OCFOS and the Department of Justice and Attorney General's Office. They were very, very helpful in assisting us to identify a community legal service that we could partner with to employ a lawyer that would actually provide support, advice, and in some cases representation to carers. So we've only got one, and you know, that covers the whole state, but it's definitely a start. So in 2018, we were able to employ that person, Megan Inglis. She's not related to me. I did sit on the panel to interview Megan, and she's been with us since our funding started, and we've just found out that we were only given funding year by year for the first 3 years, but we've just been advised of 3 years worth of funding, so we're really excited about that. So we'll move on to the next one. So unlike other services provided through HUB, so HUB sits in Inala, and they are a community legal service. So they provide broad legal advice within their community to people that have disadvantage or vulnerable. But the service that we as an organisation get through HUB is different. The service for carers is not means tested. All carers are able to access legal advice for the relevant jurisdiction matters. So Megan or HUB support us in matters relating to children's court, usually around the section 113s, which is when a carer applies to join as non-party to proceedings, usually where it's in respect to matters regarding guardianship, and then of course QCAT. So in order to access HUB, carers must first contact QFKC, and you must be allocated a QFKC officer who will complete a referral form with the carer if a legal service is identified as being needed. And then we will send that referral to HUB, and this will trigger a conflict check. So what that means is that HUB need to complete a conflict check to make sure that that organisation hasn't worked with any of the potential parties that are affected by the decision. So if they've worked with the birth parents for the family, for the child that we are seeking to get legal advice in respect to, then they're not able to support us, and in that instance QFKC will do whatever we can to support the carer to access an alternate legal service. So then once the conflict check has been done, and I think there's only been about 2 or 3 where there has been a conflict identified, in the past 3 years. So once the conflict check has been done, we book in a 45-minute legal appointment between the carer, QFKC and the lawyer. And what's important to understand there is that if you do not want QFKC to be present at that meeting, then you have the right to say you don't want QFKC to be present. It is subject to legal privilege, so whatever you advise the lawyer is subject to the usual principles of legal privilege. These appointments can take place face-to-face, over the phone, or an agreed venue within reason. So obviously Megan's located down here, so we wouldn't be flying her anywhere, but we've got Teams and we've got Skype and we've got our office here and phone. What I want to be really clear about before I talk about law right is that every carer has the right to access free legal advice, but representation is on a case-by-case situation. We try to provide representation at point of compulsory conference if there is the capacity to do so, and we know that having a carer represented in that compulsory conference where most matters are resolved is really beneficial to the whole situation. It's beneficial to the department, it's beneficial to the carer, it's beneficial to Tribunal, and most importantly it's beneficial to the child, because it just means that everyone has their views heard in that. So wherever we can, we will have representation at the compulsory conference stage, but then once it gets to a hearing, there's a really clear process that needs to take place in order for representation to be agreed upon, and that includes a recommendation from QFKC case officers where they gather all the information that either supports or doesn't support representation. That goes to myself and then the Executive Director, Brian Smith, for consideration, and then also to the Director of HUB for consideration. And we'll consider the child protection side of things and the principles of the Act, but the other things that HUB will consider is things such as merit for the case. And ultimately, HUB will make the decision as to whether they provide representation or not, because they are the service. Now, I said before that if there is a conflict of interest with the service with HUB, then we will do our best to find an alternate legal service, and there is additional legal support through Law Right. So Law Right is a community legal service that was created specifically for QCAT, for matters that are in QCAT, and so those can be accessed. It's free as well. There is eligibility attached to that, but it's not to the same extent as what the means testing is if you try to access legal aid. They provide 1-hour appointments where advice is provided about the application before QCAT. There is no limit to the amount of 1 hour appointments you can apply for Law Right, or can I say the hub as well, where you'll continue to provide those 45-minute appointments. And you can also apply to Law Right to provide one-off representation at compulsory conferences. Lawyers working pro bono provide the service through Law Right. Okay, what then? So we know what our review rights are, we know what support we can get. Now we need to understand, we know what forms need to be filled in. Now we need to understand what happens once you lodge that form. So once the application is lodged, a date will be set down for a compulsory conference, and we often refer to that as a COCO. And it's a term used within QCAT which focuses on alternate dispute resolution. So it's trying to assist the parties to reach a negotiated outcome without having to go to hearing. And only about 25% of children's matters actually proceed to hearing. So compulsory conferences can actually be pretty effective. Now, I just want to be really clear that with blue card matters, the matter will go to a compulsory conference, but it will not be mediated. The decision maker, there's only one decision maker for blue card matters, and that's the director of blue cards. And the reason why a blue card matter cannot be resolved at compulsory conference is because there is no ability to come to a compromise. A blue card is either issued or it's not issued. There's no two ways about it. And so once blue cards have made their decision, the decision is made. The matter will still go to a compulsory conference, but usually that sets the scene for what the hearing will look like. Whereas in a children's court, in a children's matter, there may be compromise that is able to be reached. So, for example, if the carer has put in an application around a removal, and it was because they had found a carer that met the principles of the Act, that they were family, and the carers lodged an application because they don't agree with that decision. It could be through that compulsory conference that a negotiated outcome is reached around a transition, for example, that, okay, we're not going to do it immediately, but we have a plan in place and we're going to slowly transition this child. And so then everyone agrees and it proceeds that way. So the purpose of a compulsory conference is to identify and clarify the issues in dispute, to promote a settlement of the dispute, to identify any questions of fact and law to be decided by the tribunal. If the proceedings are not settled, to make orders and give directions about the conduct of the proceedings, so what is the hearing going to look like, and to make orders and give directions the person presiding over the conference considers appropriate to resolve. So if we go to the next slide, we can give you some examples of what some of those orders could be. So, for example, a carer would need to be asked for leave to be represented at a hearing. Panel members can make an order for a child or young person to be represented by either a separate rep or a young person to be represented by a direct rep. So, difference between SEP rep and direct rep is that a separate representative is there to absolutely, they will consider the child's best interests and often they'll get a report from a social assessor to help inform them about what would be in the child's best interest. The child may express their views and wishes to the separate rep that is different to what the separate rep considers to be in their best interest. So they will always have a position about what they overall believe to be in the child's best interest, whereas a direct rep is more allocated to a young person who is considered Gallic competent, so they understand their decisions and the impact of their decisions long term, and their role is not to have an opinion on what's in the best interest of the child. Their role is to provide direct representation to the tribunal in respect to what it is the young person is telling them they want. So if they're saying, I want more contact with my mum and dad, then even if the direct rep has seen all the information and doesn't necessarily think that's in their best interest, they are not, they must put forward the young person's views. Carers can request specific social assessments or reports to be ordered by the tribunal. Social assessments are a common one where we have dispute around placement for a child, or an independent carer assessment whereby we have concerns around a carer suitability. The tribunal will only make such orders if they are deemed necessary. Okay, so what is a stay? I've spoken about a stay a lot, and we need to understand what a stay is. So a carer can make an application to have the decision that is being reviewed stay. So if we look at what the definition of that is in the dictionary, it talks about postponing or suspending. So in the context of QCAT, when you apply for a stay, what you're doing is you're asking for the tribunal to postpone the department's decision until a hearing takes place. So if granted, the department's decision is placed on hold pending the hearing. So for example, if the child is removed from a carer's care, they go to QCAT, they tick stay, they want to stay hearing on their application, then the stay is heard. And if tribunal find in favour of the carer and grant the stay, what that means is that the child will return to the carers until such time as the hearing takes place. Now, in my experience, it is unusual with removals that relate to harm, where there's open investigations or where the department has been able to identify that they suspect a child has been harmed or is being harmed. In those situations where a carer requests a stay, it would be very unusual for the tribunal to grant the stay unless there is, compelling evidence that would support the carer's position that the child is not being harmed or there is no risk of harm there. Usually stays are granted for those matters where it's a placement decision. So where the department have made a decision, we are moving child from placement A to placement B. Often those decisions haven't been enacted. A carer will lodge the application, carer A will lodge the application, and that consideration, that stay will be considered as to whether if in the instance tribunal agree with this carer that the child remains in this placement, the stay is granted pending the hearing. Or if the stay is not granted, the child would still move to carer B, and the carer can proceed through to the hearing, but recognising that by the time it gets to hearing, the child would have been with carer B for however amount of time, and they would need to take all of that into consideration in terms of progressing that application. So there will also be decisions where there will be no utility in seeking a stay. So, for example, if a carer applicant has refused certificate of approval for their initial application, no point requesting a stay because there was no decision for them to be a carer beforehand. So it reverses the decision to what the status quo was. And so in those types of situations, obviously, there's no reason for the carer to apply for a stay. So what does tribunal consider when granting a stay? They consider the interests of any person whose interests may be affected by the making of the order or the order not being made. So obviously the centre attention is the child that the application is about. Any submission made to the tribunal by the decision maker for the reviewable decision and the public interest. In addition, it's important to note that when considering whether the granting of a stay is appropriate, the tribunal needs to consider the principles of the Child Protection Act. And I spoke about this before, but again, just reiterating that they need to consider the main principle for administering the Act, which is that the safety, wellbeing and best interests of a child, both through the childhood and for the rest of the child's life, are paramount. So that's obviously a consideration there. Okay, so I just want to point out a couple of things before I get on to the hearing as well when we are in that compulsory conference stay. So usually when you put your application in and you apply for a stay in a compulsory conference, you will get directions and that compulsory conference and stay will be heard on the same day. Now, if the stay is complicated and complex, often because it's only set down usually for about 3 hours. So if the stay is complex, then sometimes, because the stay is always heard first, sometimes all your time is used up just with the stay, and so then the compulsory conference will be adjourned until such time as there is another time for it to be heard. Now, the stay hearings are always recorded and you can request transcripts. There is a fee to that, but compulsory conferences are not recorded and they are confidential. And when we think about compulsory conferences, again, we need to bring our mind to this is about trying to get an outcome. And sometimes you'll have situations where one panel member will take the department over here and have a chat to them about what their potential bottom lines are, and another panel member might take the carers off over here and talk to them about what their bottom lines are, and then they come together and, you know, like I said, try and come to resolution. None of that is recorded, and none of the information that is shared in a compulsory conference can then be used in a hearing. So it's all confidential. And what that is about is promoting that discussion and dialogue between the parties so that we can try and have open, honest, transparent conversations and reach an outcome. But, you know, we do have those obvious situations where that doesn't occur. And where we need to go to hearing. So in the event that negotiated outcome has not been achieved at the compulsory conference, carers need to put time and effort into their preparation for the hearing. So this needs to include credible and accurate witnesses who are able to write statements relevant to the application before Tribunal. Tribunal don't want to hear from 10 of your best friends about how much of a good carer you are and how attached this child is to you. Because that is, of course, what your friends and family are going to say. What they need is witnesses that are subjective, that are credible. So we're looking at, you know, what does the school say? What does the daycare say? What is, you know, the family members of the child that support the placement? What does the OPG have to say? What does the agency have to say? You know, there's a whole range of witnesses that you need to consider that will actually give credibility to the application. And ensuring that you have accurately responded in the statement from the department's statement of reasons. So let's have a look at what a statement of reasons is. So when the department makes a decision, a reviewable decision, and you make an application to QCAT, then the requirement is that the decision maker, so in this case, child safety, have to provide a statement of reasons to QCAT and to the parties, which outlines all of the reasons why they made the decision. So the statement of reasons has to include everything on which the decision maker relied on in order to make the decision. So they can be a really big document. I just spoke to a carer the other day actually and said, look, don't be alarmed when you get the document by email, because it will seem like a really, really big document, but usually it's about 40 to 50 pages of actual reasons, and then all the rest of the pages are usually attachments, and they could be case plans, and they could be case notes, and they could be the assessments. There's a whole range of things that they could be, but the actual statement of reasons is usually about 40 to 50 pages long, and even some of that, the beginning of that sets out the facts. So, you know, how long the child has been on an order, why they came to care, or if it relates to a carer and their certificate of approval, when they were approved, how long they've been approved, some factual information, and then it gets into the content. So the statement of reason explains how the decision was reached. The statement must set out the evidence or other material that the decision maker took into account when making the decision. Findings made by the decision maker on material questions of fact, the relevant legislation in any government policy being applied. So in instances where a carer has been cancelled, for example, as a carer, then they would need to actually link that rationale back to suitability requirements. So under section 135 of the regulations, it is really clear about what suitability requirements are for carers to be approved. And then we have the statement of standards under section 122 as well, and then we have policy requirements that carers need to meet in order to be a carer as well. So as a service centre manager, you would need to go through each of those legislative requirements and each of those statement of standards and each of the policy requirements to ensure that your rationale and reason for this carer being cancelled aligns with that policy and legislation. And then the decision maker's conclusions and decisions. Okay, so then there's a couple of other processes. So notice to attend under section 97 of QCAT, applicants and respondents can request a notice to attend. So this means they are seeking QCAT to serve a notice so that a witness can give evidence. So those are usually needed for professional witnesses. So if you're wanting your community visitor, a teacher, a daycare provider, police, doctors, health care professionals. They won't just provide evidence or come to QCAT usually. They will require a notice to attend and a notice to produce as well. We'll talk about notices to produce soon. Applicants and respondents must pay QCAT a specified cost per application. It's about $17.95, I think, at the moment. Notices to produce, only QCAT can order a person to attend a hearing or to produce documents by issuing a notice to attend or produce. So I spoke about the attendance, so that's just saying that you have to come, but if you're wanting the community visitor to present all their case notes from the last year, then you need to do an application for a notice to produce as well, and they may charge a fee for this service. If a person is willing to attend or produce a document, you do not need to apply to QCAT. So if they're saying, look, here it is, then obviously you don't need to apply. Notices to produce may be used to gain files from the Office of the Public Guardian, health files and education files or child safety files. So I can say that for all blue card matters, it seems to be a definite practice that blue cards will do a notice to produce both to the department and to Queensland Police as a matter of course. So that just seems to be what they do automatically. You get to review those documents, whatever is produced as party to those proceedings, you get to look at that as well. Okay, so carers need to provide to tribunal witness statements and the times these witnesses are available to answer questions. So that can either be done by phone or in person, more so by phone nowadays, obviously, on the scheduled day of the hearing. So usually if you have put in an application as the carer, then your witnesses are heard first. And so you produce all your witness statements. And it may be that the department and QCAT might only, out of your 10 witnesses, have questions for 3 of those, and they will let you know prior to the hearing which ones they wish to speak to, and they need to be available to speak to the evidence that they have provided. Okay. I just spoke to that. Yeah. Hearing. So the applicants usually present their case first. So I've spoken about that. Tribunal members will always introduce themselves at a hearing. They'll allow for introductions of other participants and discuss QCAT protocol. So in a hearing, like a stay hearing and a final hearing will be recorded. Again, you can request transcripts of that. It costs a fair bit, I think, but you're able to do that. The confidentiality provisions will be discussed, expectations that whilst an oath may not be required to be taken, that all parties tell the truth, and there is a requirement in the QCAT Act that tribunal members help applicants and respondents to understand the process. Another really important point with your witnesses is, and particularly with blue card matters, is at the beginning of the witness statement, it needs to be really clear that your witness knows why your blue card has been cancelled. And I want to give you an example. So I have Danny sitting with me right here. You can't see Danny, but he's right over here. And I could say to Danny, come in. I could say to Danny, I have had my blue card. Well, I could say to him, I've had my blue card cancelled, but I really would like you to write a witness statement for me and tell them how wonderful I am because I've supervised you for 7 years and you know me. And he could say, oh yeah, I think you're wonderful. You might say that, you might not, don't know. And he might write a really good witness statement. But if he doesn't know the reason why I've lost my blue card, then none of that information is relevant. Because if I actually said to Danny, oh Danny, I have been found to have child pornography on my computer and I've lost my blue card. Can you write me a witness statement to say that I'm a suitable person to have a blue card? Then, of course, his response is going to be absolutely not. And so that's a pretty significant kind of example there. But what it really highlights is that all of your witness statements, all of your witnesses, both for a children's matter and a blue card matter, the witness must have an understanding of why the application is before tribunal. So if it's for a blue card matter, why you've lost your blue card. If it's because a child's been removed, why has a child been removed, to the extent, you know, the information is able to be provided to them. It's not about providing information about the child, it's providing information about them as a carer. So that's really important. Okay, so who will be present? The following can be present at a hearing. So 3 tribunal members, the hearing support officer, the decision maker. So for the department, that will be the service centre manager, and for blue cards, that will be a rep from DJAG. It will never be the actual decision maker. The department sometimes also has their senior prac present, court services for the department, or a legal rep from DJAG. You have, of course, yourself as the carer, the applicant. Applicants may have a lawyer present, provided the tribunal has granted leave for this to occur. The applicant is able to have a support person. Now, any person that they have as a support person is not then able to be a witness. So that's why we can often have situations where carers can't have their specific agency support worker. They could have someone else from the agency, but their actual agency support worker can't be their support person at QCAT, because it's likely that they will be called as a witness. The child can be, who is subject to the application, can actually be present. That's unusual, but it can happen. Obviously, the set rep or the direct rep that I was just speaking to you about, and then a child advocate from the OPG. So child advocate is different to a community visitor. Child advocates are lawyers, and there's about 6 of them statewide, and they can represent children in that setting as well. The tribunal can also join other parties to the proceedings. So when I gave you the example of carer A and carer B, and the department are placing this child that's with carer A with carer B, and this could be auntie over here and a general carer over here, or a foster carer over here, and the foster carer makes an application for that decision to be reviewed. Auntie can actually make an application to join as party to those proceedings, because she's an affected party by the decision, and a birth parent can actually also make an application to join as party to the proceedings, because they are an affected party to the outcome. And so there could be a number of people that the tribunal considers as appropriate to join. Okay. What is the role of support person? This can be hard for QFKC at times, because we're not really allowed to talk unless we are spoken to. We have a lot to say, but often because we have played a role as a support person for many, many years within QCAT, often the tribunal members will speak to us and ask for our assistance to support a carer to understand something that may be being tried to be explained to them. But the average person that's sitting in QCAT as a support person is not able to be part of the process. They're not able to speak, they're not able to you know, interrupt the proceedings or address the panel members. That's just a no-go. And witnesses may also request that they bring a support person into the hearing with them as well. So when a decision is being reviewed at the hearing, the tribunal members are the decision makers. So the department, the delegated officer that has made the decision in all of those situations is either a team leader, is able to make the decision around contact, or all of those other decisions are the service centre managers that relate to the child matters, and then obviously with blue cards it's the director of blue cards that makes that decision. So in the event that a carer makes an application to have those decisions reviewed, then the decision maker now becomes the panel, the tribunal. So they can either confirm the decision. So if they confirm the decision, they're agreeing with the decision that has been made. They can amend the decision. So they may say, for example, yes, well, we do agree with the fact that the child needs to move, but we haven't been able to agree in compulsory conference. So we feel that that decision needs to take place, you know, in 6 months' time through a slow transition. They can set aside a decision. So that setting aside a decision is means that they have agreed with the carer's position, that the decision that the decision maker made, the service centre manager made, or director of blue cards made is now set aside. So that decision does no longer exist anymore. And they can also set aside the decision and return it to the decision maker for consideration. They can provide their decisions and reasons orally. That does not happen it's only happened once in the 16 years I've been with QFKC. This oral decision and reasons will be transcribed and sent to parties if requested, but given the amount of evidence and how busy Tribunal is now, members must often that oral decision will not be provided and rather a written decision and reasons will be provided. The guideline around that is 90 days. We've seen matters exceed that, particularly in respect to blue card matters as well. Okay. So appeals, if you're unhappy with the outcome of review, you have 28 days in which to lodge an appeal. We don't have a lot of experience, we don't have any experience in relation to lodgement of appeals. We've not been involved with one. If there was not a judicial member on the panel that made the decision, the appeal would be heard in the appeals tribunal by a judicial member of QCAT. If a judicial member did sit on the review hearing, then the appeal would be transferred to the Court of Appeal. And like within any court of law, there requires grounds to appeal a decision. It can't just appeal a decision because you didn't like the decision. There has to be grounds that involve questions of fact or questions of mixed law, in fact, not just because you're unhappy. If the grounds of appeal only involve an error of law, no leave is required. Okay, so I just really want to acknowledge that we have worked in this space for so long that everything QCAT just comes rolling off our tongues, because here at QFKC it makes up such a big part of what we do. I think we have about 30 QCAT matters on the go at any given time. And so we're really familiar with those processes, but I'm also really mindful that every single time we work with a new carer that is going through this process, that it can be extremely overwhelming. I do want to say, though, that as overwhelming as it is, and we certainly have our frustrations at times with QCAT processes in terms of time delays and, things not happening in a way that is timely, therefore impacting on a decision. I do want to say I've done some training in Tasmania, and I've done some training in South Australia and Northern Territory, and I know that we are extremely lucky here in Queensland to actually have a tribunal service that works effectively, that review decision, if you do not agree with a decision that is reviewable under the Act, then you have the right to actually to lodge an application and have that decision reviewed, and that is not a practice that exists in Tasmania. It's not a practice that existed in the Northern Territory when I was up there. I know South Australia are only just starting to have that process, but there is a lot of that facing a lot of issues in that respect. I went down there at the end of last year and did a presentation on how we do things up here with QCAT, and they were all completely amazed at how progressed we are here in Queensland. So it might not feel at the time, obviously, when a decision is made that affects you so greatly that you are wanting to have that decision reviewed. Obviously, you're not feeling lucky at the time because you're distraught about the decision that has been made. But to have the opportunity in a state where we support the right for that application, for that decision to be reviewed by independent people, that's it, independently of child safety and independently of blue cards, I think is a really good process to have. So those are our contact details in Brisbane and Townsville. I just want to reinforce that we have our legal service here for matters. We can open it up to chat now. We've got 10 minutes to answer any questions. Just a reminder to people to please not put anything in the chat function that relates to any identifying information. If you're wanting after this to speak to a case officer relating to a potential QCAT matter or legal advice appointment, please contact our office. If anyone has any questions, like I said, please put them into the chat function and we'll do our best to answer them. I must have done a really good job of of providing all the information for you not to have any questions, either that or you're also confused that you don't know where to start. Okay, I'm just going to start to wrap it up. If you've got a question, please keep typing, but I just want to do some final housekeeping before we wrap it up. So this recording will be placed on our website. And I've got a question there, so I'll come back to that. And there are actual certificates of attendance on our website as well. You can print off a certificate of attendance and just put your name in it. And it's up to your agency to obviously reflect with you about the training and what you took from that. So we've got a question, does this apply to a child in care if there is a delegated authority to an external party? I'm not sure I understand that question. Can we just elaborate? Delegated authority. Are you talking about community controlled organisations? I'll just wait to get some elaboration on that. What are the expected timeframes for QCAT? Oh gosh. Look, I'd like to give a really clear answer on that, but the reality is that these matters are becoming more and more extended. Although we have one at the moment where an application for an urgent stay was applied for, I believe, on the 2nd of June, and the stay hearing was set down within 3 weeks of that occurring. So when Tribunal can identify that a stay is urgent and that the impact of not having a stay could be quite significant, then they're pretty good at trying to set down a date very quickly. And what we do is really highlight in the application form the urgency of it. But then, and then if a stay is granted, then, you know, it's in everyone's interest for a hearing to take place as soon as possible. So you would hope that a hearing would take place within 3 to 6 months in those kinds of situations. But with blue cards, we're really looking at, well, I have one where the application was lodged in February and we've only just got a directions hearing for July and a directions hearing, so we haven't even had the hearing set down for a compulsory conference or for a hearing. So that, you know, gives you a fair idea about the timeframes for blue cards. E.g. refocus has been given DA for contact. So thanks, Wendy. So it was around community controlled organisations. The Act hasn't actually covered off on that yet. So I would need to take that on notice, Wendy, because we're only just starting to see refocus and the and CQID that have been given some authority to make those decisions. And so in terms of whether those are appealable, I would assume so, because the delegated decision maker would then be the person that's made the decision within that organisation. In terms of reunification, I just want to be really clear in terms of appealable rights around a reunification. It would only be an appealable right where a child was being reunified home where the child remained on a child protection short-term order. So if the order was expired, there would be no appealable right there, because the child has to be subject to a custody or guardianship order in order for there to be an application heard. And in instances where you are returning the child home and they're on a long-term guardianship order, then that would be a removal decision if they were remaining on that long-term guardianship order. But as soon as the department put an application into the Children's Court to revoke that long-term guardianship order, then it would no longer have jurisdiction within the Children's Services Tribunal either. So Wendy, I'll take that on notice and just come back to you for sure around that, because that's something I want to know as well. Okay. No other questions. I just want to thank everyone for their time today. We'll be trying to do one of these forums every month. The next month, Danny is going to be front and centre, and he'll be doing a presentation on transition to adulthood. So we're really looking forward to that presentation. Danny has extensive experience in that space of transition to adulthood. He's been involved in many projects and working groups alongside CREATE and G-Force, and it's an area of passion for him. So if you are interested in attending a webinar on transition to adulthood and what that means for young people that are in your care and how you can support them, then please watch out for the date. Otherwise, I just want to thank you for your participation, and we'll see you next time.